Okay, so hello all and welcome to this GDPR webinar hosted by LawBite, the online legal platform for small businesses. Any of you who don't know, we help all kinds of businesses across the UK, providing them with affordable legal expertise through our fully regulated law firm via our online platform and mobile app. My name is Richard Royce, I'm the COO of LawBite, and I'm pleased to introduce today our speaker, Alla Fairbrother, who's one of our experienced data protection lawyers and GDPR specialist. She also has over 9 years experience advising businesses on all kinds of contracts and commercial legal matters. So the format will be, she'll be taking you through the presentation today on the new regulations coming into force on the 25th of May, which is just over 9 weeks away. We're already working with hundreds of businesses to become GDPR compliant, and during the next 45 minutes we'll be providing some key information to help you understand the implications and some of the specific risk areas to your business. The format will be an initial presentation, as I said, and should last around 30 minutes. And then there will then be a live Q&A session where you can ask Alla anything you like on the GDPR topic by typing into the Q&A box that you should see in your Zoom interface. Because of the large number of participants in the webinar, it might be that we can't get through all of the questions within the session, but however, we will follow up with everybody via email, circulating both the presentation and a summary of all the answers to the Q&A. And if you have any more specific questions about your own business, please feel free to get in touch via the website or by emailing us at gdpr@lawbite.co.uk, and the full contact details will be repeated at the end of the presentation. If you have any technical issues with the Zoom interface, like being unable to hear or see the presentation, please type into the chat area and we'll monitor that and assist you where possible. So that's all from me for now. I'll hand you over to Alla to take over the reins. So welcome, Alla.
Thanks very much, Richard. Okay, so today we will talk about the GDPR. We'll go through quite a few different topics, including these ones, some in more detail, some in less detail. But yes, if you have any questions, please keep them until the end and we will talk about them. So I'll spend about half an hour talking about the GDPR provisions, and then it's 15 minutes Q&A session. Okay, so our current legislation that talks about data protection, the main piece of legislation is the Data Protection Act 1998. And it is actually out of date. It's 20 years old, and the technology used 20 years ago was very much different to what we have in place right now. So, so the General Data Protection Regulations 2016 are coming into force directly for all of the EU member states from the 25th of May this year. And as Richard said, it's only 9 weeks away. There's also the Data Protection Bill that will be applicable here in the UK. It's not received the royal assent yet. It's still going through the Parliament. But the bill will basically address the main GDPR provisions and implement it as well. It will also talk about specific data provisions, data protection provisions in relation to law enforcement agencies and also intelligence, so specific data protection provisions there. So, and as you know, we've already had nearly 2 years of to be GDPR ready. So hopefully many of them have had a think about what kind of procedures and documents you would have in place, and we can definitely help you with that. One of the underlying principles of the GDPR is that the data protection should be implemented by design. So whenever you think about your new business activities or existing business activities, you need to think about data protection by design from the beginning, and perhaps do a data impact assessment and see how the data subject rights could be affected. You've probably seen headlines about the GDPR fines, and they are much higher than the current £500,000 fine that you can get from the ICO for the breach of the Data Protection Act. And at the moment, the fine would only be applicable if you were to breach a notice from the Information Commissioner's office. Whereas here you can see the fines are very, very different. So it's in everybody's interest to ensure that you are GDPR compliant, and it's not that complicated to do that. Okay, so some of the key changes under the GDPR. So what is personal data? Under the current legislation, it's a data which can identify a living individual. Under the GDPR, the definition is similar, but the data, you could identify a living individual directly or indirectly. And the definition actually of personal data is wider. So for example, an IP address could be seen as personal data because you could trace it back to a living individual. An identification number, location data, name, email address, telephone number, all of that information can be seen as personal data. The GDPR also talks about the special categories of personal data. This is what used to be called sensitive data. So it's racial, ethnic origin. So think about, if you get a copy of a passport, for example, you could see an individual's face, a photograph, and perhaps guess their ethnic origin. Medical details, sexual orientation, political opinions, all of these are examples of special categories of personal data. And if your organization processes any of these special categories, then you need to make sure that you have explicit consent for processing them. And the consent requirements actually are higher now. You don't just need to make sure that there's a pretty box. It needs to be explicit consent, and we'll talk about it later as well in a little more detail. Okay, in terms of other key changes under the GDPR, a lot of it is actually to do with having the right documentation in place by the data controllers. So you need to have a think what documentation you have in place right now. Do you have a data protection policy? Do you have a data retention policy, an IT security policy, a privacy notice that's up to date? Because you need to notify all of your data subjects how you process the data, and there are specific requirements as to what should be in those documents, and they are more extensive than what the current Data Protection Act prescribes. We talked about consent. We'll talk about consent a little bit more later on. There's also a new thing about data breach notification requirement. So all of the data controllers have an obligation to notify about certain breaches within a certain time period to the ICO. There's also enhanced data subject rights to give them more control in relation to their data. There's new obligations on data processors as well. There's expanded territorial scope of the GDPR. You also need to think about the potential appointment of data protection officers, potentially. And as we saw, there was a significant increase in fines and penalties. Talking about the main data protection principles, there's actually not that much change between the current legislation and the new GDPR legislation. So currently there are 8 data protection principles. You can see them all on the screen. The new principles under the GDPR, there's only 6 of them that are mentioned generally, but number 7, number 8 are mentioned elsewhere in the GDPR. So they're more or less similar to what we have right now. So the underpinning thought process is very similar to what we have now. So the first principle is the transparency, lawfulness, fairness, and transparency principle. So this is mainly for the data subjects to know, what data is retained by your organization, how you process the data, what do you do with it, do you disclose it to third parties, and all of that needs to be in your privacy notice, available to your data subjects, normally through your website. Also the purpose limitation principle, which means basically that if you collect data, personal data, for specific legitimate purposes, then you cannot use it for any other purposes. You can only use it for the purposes connecting and relating to the original purpose for which you collected the data. If it's not connected, you need to think, you know, do I need to get a specific separate consent from data subjects? And again, this should be specified in your privacy notices. The next principle under the GDPR is that personal data processed by data controllers should be adequate, relevant, and limited to what is necessary. So, you know, only have the data that you need to process. Any surplus data that's not required should probably be deleted. And think about, you know, how to keep your records up to date. Do you need to review them from time to time? So think about having a data retention policy in place if you haven't got one already. In terms of keeping data for no longer than you need to, there's no size fits all. So you need to think what would work for your organization. So if you have some sort of CCTV footage, for example, you might want to keep it for, I don't know, 30 days or 2 weeks, whatever is necessary for the security purposes. At the same time, you know, tax-related and accountancy-related records should be kept for, say, 7 years, 6 years plus 1 year, just in case. The same goes for potential litigation, because the limitation period for bringing a claim against your company is 6 years. So we would also advise that the records are kept for about 6 years plus 1 year, just in case. So it's 7 years. Corporate records need to be kept for at least 10 years. So it's, as long as you have a good data retention policy, and you follow the procedures outlined in that policy, then you should be okay. A lot of GDPR compliance generally is about sitting down and understanding the flows of data that you have, where it comes from. So you've got your employees, you've got your suppliers, customers, third parties, processors, and what kind of data is there, on what lawful basis do you have it, how do you process it, having the right documents in place, basically. There's also the integrity and confidentiality principle, which basically means you have to have the right security in place. And the GDPR is not very prescriptive. It just says appropriate security of the personal data. And that depends on your organization, you know, what availability of resources do you have to spend on security measures? And also, what type of personal data do you process? Is it very sensitive medical personal data or ethnic origin type data, which is sensitive? Or is it your customer list, you know, with names and email addresses of people working in their business capacity? So the damage to data subjects would be very different from the first example to the second example, and security measures should also be reflecting the type of the data that you process, as well as the availability of resources you have in your organization. So, you know, look at Google or Amazon, they will probably have, you know, quite significant resources to spend on security. So data processing is anything between storing data to disclosing data to third parties, making decisions about it, etc. So it's anything to do with personal data. And the GDPR is underpinned by the concept of accountability. So the organizations should, you know, comply with the documents that they put in place, with their internal procedures. And the ICO actually has the right to audit organizations. So if your business is one of unlucky businesses where somebody complained about, you know, potential non-compliance with the current data protection legislation, the ICO can actually, you know, make some inquiries and audit organization as to their compliance. And if you have done your due diligence, if you've got all the right documents in place and the compliance programs, and you follow that, you've done your training of your employees and stuff, then you have mitigated your risks. And if there's a small minor mistake in there or omission, it's better to have that in place rather than having nothing at all, because of a lot of the GDPR compliance is about having the right documents in place. So an example is evidence of consent, for example. So at the moment, some companies, organizations ask questions: what do we do with our old marketing lists? We don't have any evidence of consent given at the time. So going forward from the 25th of May, make sure that when you obtain consent for marketing purposes, or when you deal with sensitive data and you also have to obtain consent, you actually need to have 3 types of information for that consent. It's the date it was given, when it was given, the scope of that consent, so it needs to be very specific, and also how it was given. And so whether it's in a spreadsheet or a CRM system, you have to have that evidence. Otherwise, it's deemed that you haven't got the right consent. Okay? And you also have to think about the legal basis for processing. And there are actually six types of legal basis for processing data. We'll talk about them a little bit later. Yes, so the first one is consent. But that's not the only basis available. So consent is perfect for sensitive personal data or data that will be used for marketing purposes. The second one is also very useful, where you have to process personal data in order to comply with your obligations under a contract. So when you are a supplier of goods or services and a customer contacts you with a view for you to provide services, so when you have those pre-contractual steps, or when you actually perform your contract, you don't need consent from that customer because to process that data, because you're doing it as part of the contract to fulfill your contractual obligations. So in that respect, but don't forget that even though you might have the lawful basis for processing data, it has to be mentioned in your internal documentation. You have to be quite specific. It has to be mentioned in your privacy notice as well. So it's not just to say, oh yes, I'm compliant, I can forget about it. You need to write it all down and have it, as the evidence that yes, we've thought about it and we think that's what is applicable. Another very useful legal basis is the number 6 here on the slide, legitimate interests of the business to process personal data. So this is when you think you have a legitimate interest, and you'd have to have analysis again here and specify in your documentation what legitimate interests you're talking about, and you have to assess what kind of harm it might cause to the individuals if you use their data. So for example, when could you contact an organization if you have the details of a telephone number and name of a particular person within the organization? Could you contact them without consent and offer your services? Would that be, could you do that under your legitimate interest, for example, as long as you give them an opportunity to opt out? Perhaps you could, but it's something to think about on a case-by-case basis, and do detailed analysis and write it all down in your internal procedures. So yes, I've mentioned enhanced documentation is required for the GDPR, including that there are clear records of all data processing activities. So think about all the types of data processing activities that you have with various stakeholders. So you need to make a record of the purposes for which data is being processed, the categories of data subjects. So categories of data subjects includes employees, customers, suppliers, any transfers outside of the European Economic Area, because you could transfer within, but going outside, you have to think about appropriate safeguards being in place. And think about your IT security policy. What technical measures and organizational security measures do you have for both manual records of personal data and electronic records as well. Think about, the data protection impact assessments for high-risk processing activities. We can help you with to have a template for that as well. And these are more appropriate when you have automatic data processing or there's large scale of sensitive data being processed. There may be other categories that the ICO might mention on their website, but you wouldn't need a data protection impact assessment for all of uses of data. It's just for high risk processing activities. In terms of obtaining consent, I touched upon this earlier. So it needs to be freely given, specific, informed, and unambiguous. So consent is not the only way forward, but for marketing activities and for sensitive personal data, which is now called special categories of personal data, you need very specific consent. And it needs to be not bundled with other documents. So you'll have your privacy policy on your website, but when people sign up for your marketing emails, there has to be a specific opt-in box that is only for that purpose. You have to be very specific and mention the purpose for which it's obtained. And as I mentioned, to keep the details of how the consent was obtained, when, and by what kind of means. We have a separate document on consent as well with some useful examples of how it can be obtained. It doesn't have to be in writing. If you routinely deal with your customers by phone, you could have a note, but you need to have an internal process as to how you deal with consent and how you keep the evidence, because the evidence is the important bit in the consent. So there are some useful points here in relation to consent. You will receive a copy of these slides so you can have a look at them. They are quite detailed, so that there's quite a lot of information for you to look at, but obviously feel free to ask questions. Okay, in terms of data subject rights, they are enhanced now under the GDPR. So there's access, rectification, erasure, restriction of processing, etc. And you have to notify data subjects about those rights. In terms of the access, data subjects may request a copy of their data. Currently, you can charge them up to £10 per request and take 40 days to answer. The time period is changing, it's 1 month, 30 days now, and you cannot ask for payment anymore. In terms of the international data transfers, there are rules. So transfer is free, just like the movement of people and goods within the EU. The movement of data is also okay within the EEA, which is the EU members plus 3 EEA countries. But if you would like to transfer further, then you have to think about a number of ways to do that. So one of them may be consent, perhaps, but you have to notify every single subject about the dangers that there are, because other countries may not have the same safeguards in place, or you may have contractual safeguards with third party who you're transferring to. A lot of cloud providers have an option of keeping the data within the EEA, so that makes it nice and simple for everybody. The data is not going to be transferred, but also think about your employee, for example, when they travel to another country and open their laptop and access personal data, actually that is a data transfer to the country where they are at that moment. So you have to think about potential transfers outside of EEA and also record it on your internal documentation and procedures. Yes, so in terms of territorial reach, you have to think, if your business operates in more than one EU country, you have to think about the main supervisory authority, and it's basically where the decisions about data processing are held and made. So it's likely that the ICO is going to be the main one for of UK businesses, UK-based businesses. In terms of the data breach, a personal data breach is a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. So it's a new requirement that obviously you have to have the appropriate IT security measures in place, taking into account your available resources and also the risk of disclosure, whether it's sensitive personal data or whether it's not that sensitive. And if a breach occurs, the data controller has the obligation to notify to the Information Commissioner's Office within 72 hours where possible, unless breach is unlikely to result in risk to individuals. So here you don't have to notify. But also if, you know, medical data or sensitive financial data has been leaked and there's a breach, you have to also actually notify each of the individuals, so that there's a significant risk to the business itself, really, in terms of, you know, customers losing the customers not being happy with the provider that might not have had the right security measures in place to protect their personal data. In terms of the different, so I've mentioned data controllers and data processors. So the data controllers are basically organizations that make decisions about data, and data processors who can receive fines and penalties now, for example, they act on behalf of the data controller. So they would normally hold data or process it, but only on the directions of the controllers. And the data processors now must have a written agreement in place. So that's your Article 28 of the GDPR that basically specifies what clauses you have, and we have those examples. We can help you with them. In relation to the data protection officer, it's required, you're required to have one if you have 250 employees or more, or if you have a large-scale processing of sensitive data or criminal records, if you're obliged to do so by local law, or if you have regular and systematic monitoring of data subject on a large scale. So you don't have to have one for most of the businesses, small and medium businesses in the UK. You probably don't need to have a data protection officer, but if you have one, it's absolutely up to you. It's good practice because at least there's accountability and ownership as to who is responsible for the compliance with data protection laws. So there are some points here, loads of points. What should your organization be doing right now? So you need to have an audit as to, you know, what governance documents do you have, what policies and procedures do you have, how do they need to be reviewed? You need to think about the management of your electronic and manual records. Do you have any process for complying with data subject rights? And what if somebody asks you to, you know, to supply a copy of their data held by your organization? Have you got the right technical and organizational measures in place? Do you have a record of them? Do you have an IT security policy in place? Third-party sharing, you know, where does the data go when you have it? You might need to have the right processing agreements in place with those third parties. Have you done the training, data protection training for your staff? Are they aware of the data protection laws coming into place? To do transfers of data outside of the European Economic Area, procedures for obtaining consent, data retention periods, and the policy. So there's a lot to think about. Privacy impact assessment is one of them if you have the high-risk processing activities. And, you know, you have to think basically what documentation you have in place, what needs updating, and then comply with those procedures that you have in that documentation. Specifically document the legal basis on which the data processing is taking place. So I mentioned 6 of them, from consent to contract to your legitimate interests. The ICO website also talks about the data flows and international data flows as well. Review your contracts with third-party suppliers, think about security measures, etc. And we can help you with all of that. We can make it, a nice, relatively easy process for you. We can provide advice. We have GDPR audits, can help you with the privacy impact assessments, general support. We can help you with the data protection audits as well, procedures for obtaining consent, and all of the documents that you need to have in place. So we have a number of GDPR products and services available to you. There's also 10% discount to all of the participants of today's webinar until the end of March. Our most popular package with the GDPR is the GDPR documents package. There are 12 documents in the package, including your data protection policy, IT security policy, data retention. You have 3 documents there in relation to the employees. You have a data protection, data processing agreement and data processing clauses, which are very relevant when you have a third-party processor acting on your behalf to deal with the personal data. And there's basically a number of very useful documents in here. And also with the documents, you get 30 minutes of legal advice to discuss any questions you might have. But it's a very good package with the templates that would suit most businesses. It gives you the structure and it gives you all the relevant points that you would need to cover. So you're not starting from scratch. But many clients have found the Information Commissioner's Office website very useful, but what it doesn't give you the documents that you would need to have in place. The package also includes, I forgot to mention, the privacy policy and the terms of use of your website, which are both for your website, and also a document that talks about consent, all the rules, and gives you examples that you might find useful for creating your own consent paragraphs. If you're interested in the training, with the webinar training, or you can have the documents package and the webinar training as well. The webinar training is tailored to your needs. So we use, we'll talk to you on the phone, and we'll use a legal audit checklist to tailor make your webinar training, and that's 1 hour, or a bespoke GDPR solution. So if you would like us to review your existing documents or to draft just some specific documents for you, or advice on the GDPR related issues, then please get in touch. Okay, now we are to the questions and answers session. Let me see. You can type your questions in the Q&A at the top of the screen. So I will be reading them and answering them. So the first one is, with the GDPR, is a sole trader allowed to contact CEO of businesses to do less than 5 minutes market research? Thanks. So that's one of those semi-gray areas, because we have the very useful basis of your legitimate business interests. And it's still to be seen how those are going to be, used and implemented by the ICO. But you could potentially rely on your legitimate business interests, because the details of the CEO, they are business details, and it's not likely that it would cause significant harm to that individual if you were to use their personal data to contact them for 5 minutes market research. But when you do that, it's a good idea to give an opportunity to opt out. So if it's an email, give them an opportunity to opt out. The same goes with the phone call. If they wouldn't like to talk to you, then perhaps don't keep pestering them. Okay, the next question. What counts as a large scale for the needs for a data protection officer? It's large scale processing. So you think about your main activities. So is it your main activities or not? And also please free to contact me separately to discuss this. Yes, so it's on a case-by-case basis, really. The next question is, must I reconsent those who have already signed up to my mailing list via website. So ideally, and what the guidance is from the ICO website say as well, is that you must have evidence. You must have evidence of the consent. So if you know when people consented, if you know how they consented, then you know it's okay as long as you have the evidence that would satisfy the new requirements of the GDPR. However, if you don't have the evidence, ideally, and there's a little bit of conflicting guidance there. So the ICO say on the one hand that you must get specific consent for, you know, for the subjects of your mailing list. On the other hand, I know that some organizations have been thinking about using their legitimate business interests to continue using the old mailing lists and giving the data subjects the opportunity to read the new privacy policy and give them the opportunity to opt out every time. But I think they're probably running a little bit of a risk there, because I have seen it in black and white from the Information Commissioner's Office that, you know, evidence of consent is the best way for marketing. Okay, so there's the next question. Do you offer gap analysis as part of bespoke service? That way we know the actions we need to take. So we have a very comprehensive legal audit checklist, which is 38 pages long. So once you fill that in, that will highlight any gaps that you might have in your current documentation and procedures that you have in place at your organization, and then we can agree on the actions to take. They are likely to be the updating your current documentation and then training your staff on those new policies to know what they should be doing. Okay, next question. Is there guidance on how to handle a request to forget by a subject while retaining data, for legal requirements? So yes, I think there was a working group on this, talking about, you know, what legislation do we have in place to comply with legal requirements for organization, and then there's all these various rights for data subjects. So far the view is that the legal requirements override any request, you know, including the request to forget from a data subject. So you would look at what data you actually need, what is necessary for your legal requirements. Maybe you could delete all of the data apart from what you need for the legal requirements and explain to the data subjects you haven't been able to delete some of the records because you actually need them as a legal requirement. So yes, you could do that, and also that's explained, normally should be explained in your privacy notice as well. Okay, next question. Hi Alla, what do we need to consider regarding social media, including LinkedIn? So I guess your question is about contacting potential customers and contacts on LinkedIn. I've not looked into the specific terms and conditions that LinkedIn have or that Facebook have in relation to this, because I've seen some of them. I've seen some of the Amazon and Box and some other T's and C's, but I've not specifically looked at the LinkedIn or Facebook ones. It may be the case that when you sign up to these services, you give consent to be contacted by other contacts. So I think, yes, we should start. If it's very important for your business to use LinkedIn or Facebook as other social media, then perhaps look at the applicable terms and conditions and see what they say, and we can help you with reviewing those and, you know, seeing how that could work for you. Okay, next question. Can you use publicly available information such as LinkedIn to get the details of a potential B2B customer and send marketing material to them without getting the opt-in from them prior to the first contact? So that's kind of linked with the previous question to see, you know, what T's and C's LinkedIn have when you sign up to them. And also think about your legitimate business interests, which all of that have to be recorded in your internal policies, and the process as to how you would contact those potential B2B customers, because the B2B personal data is still personal data. So my Lawbyte email address and my phone number that might be used for Lawbyte is still my personal data. But there's also e-privacy directive that's kind of still there, and there's the legitimate business interests, and there's the terms and conditions. So looking at all of them, you may be able to do it. Okay, next one. What information does a company legally have to provide a client, user, etc.? So the main document that you would make available to all of your data subjects, a client, user, employee, is the data privacy policy. So yes, that should be accessible at the time when that client or user provides their personal data. So when they register on your website, you should have a link to your data privacy policy, which now needs to outline a number of things, you know, the lawful basis for processing data, what data you're processing, do you disclose it to third parties, what parties are there? So it provides the right, talks about the rights of the individuals as well. So, and we can help you with that, with the drafting the right data privacy policy. Okay, next one. Our current database, how should we deal with them? Is an announcement sufficient, or do we need to get an opt-in from all of them? So I touched upon this question before. It's not an easy to answer question, because an opt-in is what is, you need to have the evidence basically. If you have the evidence as to how the consent was obtained and the scope of that consent, then you should be okay, you can just use it. If you don't, it is advisable to send a link to the new privacy policy and also get a new opt-in from all of your existing users, all of your existing database. As I mentioned before, some companies are thinking about using their legitimate business interest as the basis for using all databases, and they're taking the risk of you know, not having the evidence for that old database by explaining that they have a legitimate business interest to still contact those people. But the best practice would be to get a new opt-in. And that would also make sure that the information is up to date as well, because there is a requirement to make sure that it's, you know, it's up to date. Okay, so next question, update on previous question. What information regarding the GDPR process does a company legally have to provide a client, user, etc.? The GDPR process. Okay, so I guess I mentioned the privacy policy that needs to be available. That's the main document that you need to make available to your client or user. Also, if you're a data processor and you provide services to your clients, say you store their data, then you would need to have a data processing agreement in place, or update your current services agreement to include the data processing clauses in there, because the processor has certain obligations now in terms of security, in terms of providing information about breach, etc. So I hope that answers your question a little bit more, but generally it's the privacy notice that contains all of the information that you need to give to your data subjects. Okay, next question. As an outsourced HR solutions company, if your clients pass on the details of their staff to you, so that you can support them from an HR perspective, I'm assuming that you have that consent from the company, but you do not need to obtain it from the employees. In addition, would the employer need to inform the employee that your data has been outsourced to a third-party provider? So yes, exactly. So here we're talking about a relationship where your customer, the employer, is the controller of the personal data. And as an HR services provider, you are the processor that processes on behalf of the controller. So you would have a data processing agreement in place, or a services agreement in place that has the right provisions in it, to say that it is the responsibility of the employer to make sure that they have the right lawful basis for processing the data. It may or may not be consent, because with employees, sometimes you don't need consent, because sometimes you have to process the data, you know, as part of your contract. So say if you have a payroll provider, you have to pay your employees, and if you don't have the internal function to do that, you have to use an external services provider. So you would only give the notice as an employer to your employees that you are doing it. So, but I would put that onus and that responsibility on the employer, but you have to have the right contract in place with them. Next question. I'm away. It's 1 o'clock now. So maybe just one last question. Under the GDPR, is it permitted to do cold calling? Thanks. So cold calling, business to business, arguably, you may be able to rely on your legitimate business interests, but you need to have a data protection impact assessment as to what harm it could cause, etc. So possibly you could, and have the right documentation in place internally as well, because you need to be specific about legitimate business interest details, etc. So I guess, Richard, do we need to wrap up and maybe answer some of the questions briefly in writing after the...
Yes, I think thanks everyone for your questions. We've got another 7 or 8 there that have come through, 9 now. So we will answer all of those by text, and we will email those through to you after the session. So that's great. Thanks for everybody's interest. And yeah, if you have any further questions that you didn't have time to ask, then please get in touch via the gdpr@lawbyte.co.uk email address, or you can call us on the usual business phone number, which is 0207 148 1066, and we'll be happy to help you any time of the day. So thanks very much for everybody for joining. Thanks to Alla. Great participation from everybody, really appreciate that, and we hope to hear from you soon. We will be doing more of these webinars as well, so if you've got anyone to recommend the session to, then that would be great. We'll be doing another mail out regarding another session in a couple of weeks' time. Okay, thanks everybody, and we'll sign off for now. Bye bye.